Hi everyone, thank you for coming to watch this debate on retrospective taxation and whether it should be permitted in law. We're joined by some fantastic people today to talk about the pros and cons of retrospective taxation. So we hope you find it useful, and if you do have any comments or want to raise any views, then you can use the comments section below. So my name is Mala Kapasi. I'm Director of London Tax Network, and we're a firm specialising in all areas of tax investigations. So HMRC disputes anything from compliance checks and information requests to anti-avoidance, serious fraud proceedings. London Tax Network, together with WTT Consulting, we put together a webinar discussing the background to retrospective taxation and the loan charge. This sequel debates the pros and cons of retrospective taxation, the benefits and drawbacks, and potential wider impact on our legal system. So we bring you this debate with our co-host Tom Wallace from WTT Consulting, and I will hand over to him.
Thank you, Mala. Thank you for joining us. My name is, as said, Tom Wallace. I'm Director of Tax Investigations at WTT Consulting. WTT Group specifically has been involved with the contracting industry and helping contractors with their tax, legal and wealth advice. And has been particularly involved in the loan charge and disguised remuneration schemes, which I suspect will feature quite heavily during this discussion. So we're very involved in that area of tax law, and absolute delight to have the people with us today who are also equally well versed in it. So I'm expecting a tremendous debate, which very much looking forward to.
Thank you. Okay, so to introduce our panelists, on the for side, for retrospective taxation, we have David Pett, a barrister at Temple Tax Chambers and author of the book Disguised Remuneration and the Loan Charge, published by Claritax this year. This is, and I quote, an extraordinarily complex topic, and David's analysis is very thorough. So it's a recommended read to all. Also on the for retrospective taxation side is George Turner, Director of TaxWatch UK, and which is a charity dedicated to the administration of tax law. George is an investigative journalist with specific interest and experience in tax policy. On the against side, we have Stephen Daly, who is a lecturer in corporate law at King's College London. He also taught at Oxford University when completing his PhD on the rule of law implications of HMRC advice. And finally, on the against side, we have Keith Gordon, who is also a barrister at Temple Tax Chambers, for outstanding contribution to tax in 2019. Keith has been very vocal in his criticism of the retrospective legislation of the loan charge and HMRC's interpretation of it since it was legislated. So this debate is an opportunity for both sides to air their view of retrospection and for you, the audience, to understand the implications of retrospection of tax and on tax and wider law. The debate is chaired by Emma Agymang, an award-winning journalist at the Financial Times. Emma won Business Journalist of the Year in 2019 for her coverage of the loan charge. She is also praised by the tax profession for her reporting of the same. So Emma, I'll hand it over to you.
Thank you, Marla, and thank you, Tom, and thank you everyone for having me on the panel, to moderate the panel, I should say, today. It is a very important topic, the issue of retrospective taxation, and I think that, as has already been brought out recently with the loan charge, it's become something that's very high up the agenda. And so I think now's a very good time for us to reflect on that policy in particular, but sort of the wider issues of retrospective taxation. And particularly for my readers and the sort of general taxpayers, the issue of whether or not we're going to see more retrospective taxation with the sort of pressure the government's under in terms of trying to claw back some of the money they've paid out to keep the country going through the pandemic. So I think this is a very important topic. I'm really looking forward to hearing more and asking some questions to the panel later. I'm going to pass over to David, and so he can make his arguments on whether or not retrospective taxation should be permitted.
Good evening, everybody. Can I suggest that we begin with laying down a few principles, or at least recognise a few principles? It's widely accepted that it is wrong for any government to enact laws which treat something which was lawful when it was said or done as later becoming unlawful. And on our side of the debate, we do not contest that principle. It goes to the heart of the rule of law in a democratic society. But the position is different when it comes to levying taxes on the citizen to pay the costs of our society. And I would say that if the government has made clear its intention in seeking to raise tax in relation to a specific activity or type of transaction, such as the receipt or generation of income, then it has a duty to do so on the basis of clear wording. That's long been established from going back as far as the Duke of Westminster's case. But the difficulty that the government faces in practice lies in the determination of some taxpayers to undermine this political will by seeking to take advantage of what are perceived as loopholes or of deliberately structuring their affairs so as to avoid the clearly expressed intentions of Parliament and of its legislation. Now, this need for the government to be able to respond to egregious tax planning has long been recognised by our Parliament. There has, since at least 1978, been a convention. It was first articulated by Peter Rees MP, the MP for Dover, that if retrospective legislation was to be introduced to deal with tax avoidance, then ministers must have given a warning, and there should be 4 conditions which should be met. The warning must be precise, must be referred to a committee involving both HMRC and members of the professions. Draft clauses for the legislation should be published as soon as possible. And in any event, the legislation must be introduced in the next finance bill. And those principles have generally been adhered to ever since they were first discussed in Parliament. There have been a few examples where legislation has been backdated so as to take effect from before the announcement of Parliament's intention was made. These have been in very specific and limited areas, if I can borrow a current phrase that's popular. One was to clarify the composite rate on building societies way back in 1992. Another was to recognise the scope of the charge to oil taxation on North Sea oil. And a third in 1989 was to do with the payment of interest by UK companies to subsidiaries set up in the Dutch Antilles. But with these 3 exceptions, others may know of more, but they were the only ones that I could identify. Governments over the years have stuck to those principles. In 2004, George Primarolo, the then Financial Secretary to the Treasury, made an announcement before Parliament that the government was fed up with the attitudes of a small minority of taxpayers and advisors who were continually looking to promote egregious tax planning, particularly in relation to taxation of earnings. And so the government took the step of giving notice of their intention to deal with ongoing and any future avoidance of tax on earnings by introducing legislation, and if necessary, introducing it with effect from the date of that announcement in December 2004. And this was deliberately intended to engineer a permanent change in taxpayer behaviour. It was, I think, consistent with the Rees Convention because the government was, in fact, giving due notice at that time. It may not have been specific to a particular piece of legislation intended to be enacted, but it was a very clear warning to all taxpayers of the government's intentions to put a stop to what was widely considered as egregious tax avoidance. And so it was reinforced by Dave Hartnett, then head of HMRC, as putting us all on notice. Now, over the years, there have been various challenges under the human rights legislation on the basis that retrospection in tax legislation is contrary to Article 1 of the first protocol of the European Convention on Human Rights, in that it's an unjustified interference with the right to own property. But over the years, the courts have made it very clear that it is necessary to strike a balance, and the state enjoys a wide margin of appreciation in the extent to which it can make use of that freedom to engage retrospection in applying taxation. This was reflected most recently in both the judicial review challenges to the loan charges in cases called Cartref and subsequently a case called Zeeman. And in both cases, the High Court held very clearly that the loan charge itself was well within the margin of appreciation that was allowed under Article 1 of the first protocol. It allows taxes to be raised in a fair and proportionate way. That was reiterated by Gordon Brown back in 2005. But it's not unlimited, and any steps taken to impose taxation with retrospective effect must be proportional, and that has been upheld by the courts, most notably the National Provincial Building Society and the UK. Following the Promorolo announcement back in 2004, we've had a number of instances where the government has in fact imposed a tax charge retrospectively to a loophole, most particularly in 2006, Section 92 FA 2006, which was addressing avoidance using artificial option arrangements in relation to shares in companies. And we've also seen a number of changes to stop the use of platinum sponge and other weird and wonderful commodities as a way of avoiding national insurance contributions. Now, just turning to the loan charge, which was mentioned in the introduction, I think in the course of this debate, I would ask that we resist conflating the question of retrospective taxation with the loan. The loan charge, I would assert, is not retrospective taxation. Firstly, it is a proportional measure necessary to ensure fairness between taxpayers, but it imposes a levy upon an ongoing benefit. So this is not retrospective in the sense that it is looking to treat something that was done previously, which was clearly lawful, as unlawful, or something that was not subject to an earlier charge as suddenly becoming subject to a charge. All it is looking to do is to put a stop to the ongoing enjoyment of a specific benefit. We should also remember, for purposes of this debate, that the QCs upon whose opinion the promotion of EBT loan schemes, which were the primary target of the disguised remuneration legislations, were based, were simply wrong in their professional judgment, and the consequences of such judgment have been widespread and profound and led to a lot of individual misery. But that's not the fault of the government. The government made its intentions very clear. It's the fault of those who exercised or who gave opinions on the basis of which promoters induced individuals to take up these schemes in the hope of avoiding income tax on what was, in any view, income. It's also worth bearing in mind that the Supreme Court in the Glasgow Rangers case didn't change the law. They confirmed what the law had always been, and what many of us had advised our clients that it was over a long period. Now, I accept that changes have been made to limit the scope of the loan charge in response to the report by Sir Ammias Morse, but if you read his report carefully, this was not because it breached any fundamental principle against retrospective legislation. It was to address administrative failings within HMRC and to take account of the fact that HMRC had fallen far short of the standards we expect of them, both first in responding to what was seen as egregious tax planning, and then in the manner in which they dealt with taxpayers. Clearly, a 20-year look back was not proportional, as HMRC did not make clear until 2010 what their view of the law was. But as it stands, and now that it has been amended in response to the Morse report, I would assert that this is fair and reasonable. Now, I do concede that changes made to the DR legislation, particularly those made in 2018, which removed the ability of taxpayers who were caught by the Glasgow Rangers decision from arguing that what they had should properly have been taxed as earnings at the time the loan was made, and therefore was outside the scope of any further disguised remuneration charges. I do consider that went beyond what I would regard as proportional. And perhaps here I'm arguing the other side's case for them. But that seems to me to have removed the ability of someone to argue that their particular circumstances were outside the scope of the Glasgow Rangers case. And it effectively deprived the taxpayer of arguing that the revenue were out of time for collecting tax on what was an established charge. Let us not forget that retrospection works both ways. If you look, for example, in the clauses in the 2021 finance bill, you'll see there that there's a clause which retrospectively allows tax relief for EMI options granted by someone who was on furlough. Retrospection is often used to the advantage of taxpayers as much as it is to the advantage of government. And clearly there are occasions when it is necessary to restore the law to what everybody believed it to be until a court decided otherwise. So, for example, Mansworth and Jelly, Section 144ZA of the Capital Gains Tax Act amends the law, although in that case it's not retrospective in the sense that it doesn't go back many years to change the law. So, to sum up, the motion I would suggest is that it is essential for a government to be able to respond to egregious tax avoidance by legislating with retrospective effect to ensure fairness between taxpayers, and that tax is levied in the manner or with the effect which it was widely intended or understood to be levied. And please remember that if it were not for those who seek unfairly to shift the burden of raising government finance onto the shoulders of other citizens, then such retrospective taxation would not be necessary in the first place. I move the motion.
Thank you, David. I'm going to pass it on to Stephen to put the other side of the argument across.
Thank you very much. So before I begin, I'd just like to say that I was called in very last minute for this debate. I was let know on Monday and I didn't even know what side of the debate I'd be arguing for. So I really have absolutely no skin in the game here. And the thing is, of course, David is an experienced barrister and his arguments are, of course, going to be technically correct. And I'll be honest with you, very compelling. I agree with so much of what he said. So I've really got very little to say in response. I don't know if I'm ever going to end up using up these 10 minutes I've been allocated, but let's see. What I want to talk about is the rule of law. Now, there are broadly two ways in which you can conceptualize the rule of law. There is the thin account, the thick account. With the thin account, what is good about the rule of law is that people can plan their lives. They can plan their lives knowing the legal consequences of their actions. That is the thin account of the rule of law. It's an account I defend in my book that's just been published with Hart Publishing, Tax Authority Advice in the Public, 2020. And in a previous blog post, I'm sure I argued as well that retrospective taxation is not contrary to this thin account of the rule of law. Because if you've engaged in a tax avoidance scheme, there is a likelihood that that will fail. So it is not the case then that when you entered into that scheme, that transaction, that arrangement, that you did not know the consequences of your actions, you did know the possibility that the scheme would fail. Therefore, when legislation comes back in time and just says, yeah, you did actually fail, then there is no affront for these people to have thin account of the rule of law. But the problem with that is that that's not what people mean when they talk about the rule of law. Let's take what the government's recently proposed in terms of overriding the withdrawal agreement. Okay, so there, what the government's proposed to do is change an agreement with prospective effect. So it's still not taking effect. It's all going to happen in the future. It's not taking effect until next year. And what the government's proposed to do is change that before it gets to that point. So there's no affront there to the thin account of the rule of law either, because there has been no change in terms of legal consequences because they haven't had any effect yet. And yet, prominent politicians, prominent lawyers, respected commentators have all come out and said that what the government has proposed to do is an affront to the rule of law. So they must be taking a different meaning for the rule of law, and that is the thick account of the rule of law. The thick account of the rule of law is about constraining the arbitrary exercise of government power. If we go back in time, Plato said something along the lines of, law is the master of government and government is its slave. We look at Edward Coke in, I don't know, the 15th, 16th century. He said that we ought to be governed by the straight golden met wand of law and not the crooked cord of discretion. It's about governing and regulating the arbitrary exercise of public power. And there's good reason for that. You know, the executive, they're the ones that have the guns. They're the ones that have the tanks. They're the ones that can use lawful force. They're the ones that can take everything that you have. They're the ones that can protect you also. But they can take your house, they can take the clothes off your back, they can take your pension, they can take anything. So there are good reasons also to be worried about the coercive power of the state. And that's what the rule of law is trying to deal with. That's what the rule of law is trying to regulate, as far as most people understand it. And we see that then come up in many instances in the tax code. And one I want to mention is statutory time limits. So, you know, HMRC can open up an inquiry into return after 1 year, 4 years, 6 years, 20 years, depending on the circumstances. After a year, basically it can do whatever it wants. 4 years, you have to discover something. 6 years have to prove negligence, 20 years have to prove fraud. So we can see there that the time limits, the statutory time limits, are graduated on the basis of culpability on the part of taxpayers. That's how it's trying to strike the balance between protection of individual taxpayers as against the interests of HMRC and society as a whole in the proper collection of taxes due. Now, David has mentioned the loan charge, and he's the expert. He's written the book on it that's already been advertised. The thing about the loan charge is that it goes back that far in time. It does go back 20 years. So it rides right through those statutory safeguards that have been put in place. Now, if you were to say to me, well, that's because HMRC, it believes these people have been negligent, it believes these people have been fraudulent, and therefore it can have this power. Fine, you know, if HMRC actually had the evidence to prove these things, it could do that. Those powers are available. The loan charge does is it rips right through those statutory protections that are there in the first place. And I just want to mention one further thing then, which is David mentions the ongoing benefit that's arisen from these loans. And there is an ongoing benefit. If you don't pay off a loan, you have an ongoing benefit, which is interest. The use of money over time, that's interest. So if the loan charge were to tax an open market rate of interest for every year that the loan is still outstanding, then that would be fine. I mean, that's current taxation. That's taxation of a current benefit. But the loan charge doesn't actually do that. The loan charge goes back and says that the entirety of the loan itself is taxable. Not just the ongoing benefit, but the entirety of the loan. So in conclusion then, what I'd say is if we think that the rule of law is important, then we think statutory time limits are important. If we think statutory time limits are important, then we think retrospective reneging on those statutory time limits is important. Thank you.
Thank you, Stephen. And to argue for the full case for retrospective taxation, we're going to pass on to George.
Hello. Well, a fantastic introduction by David. I'm going to maybe flesh out some of the stuff he was saying by going into a bit of detail on a couple of the cases. mean, I think first thing to set out is I'm going to argue that a lot of what is considered retrospective taxation and is widely said to be retrospective taxation, even by government ministers, is not in fact retrospective taxation as it is commonly understood by many. And I think that was kind of at the heart of what some of David was saying. And just to kind of set this out, Craze on legislation says retrospective taxation takes away or impairs any vested right acquired under existing laws, or creates a new obligation, or imposes a new duty, or attaches a new disability in respect to transactions or considerations already passed. Now, as was set out by David, there's a number of occasions where the government has sought to impose what has been widely considered to be retrospective taxation or legislation in the tax field. But often, these do not offend what is that definition I've read out. They do not create any new right or any new obligation or any new duty, because actually, in effect, the taxation was already due under the law as it existed. And the reason why that is because many of the times that the government has sought to attack tax avoidance schemes through retrospective legislation, the avoidance schemes that it was seeking to attack were already unlawful under the law as it existed, and particularly when we take into account the application of the Ramsey principle. Now, in 2008, the UK government introduced legislation which would disapply all tax treaties that the UK had entered into in a specific and limited way, and do so with retrospective effect. And it was indefinite retrospective effect, because what the Finance Act 2008 did was modify legislation introduced in 1987, which had unlimited retrospective effect. And the 1987 legislation sought to make clear that UK income that was earned via a foreign partnership was taxable in the UK. And following that legislation, a number of people sought to get around that by introducing new tax avoidance schemes. And so in 2008, the government sought to, and those tax avoidance schemes took advantage of the provisions, or the perceived provisions, the perceived gaps in the double taxation agreements as they existed. And in particular, there was a scheme which was run using the UK Isle of Man tax treaty, and that allowed people employed in the UK, or it sought to allow people employed in the UK to avoid tax by running their income through an Isle of Man partnership. Now, an IT contractor called Mr. Hewitson, it's always an IT contractor, so used this scheme to get it to have an income tax rate of just 3.5%. And he sought to challenge the legislation through the courts. Now, before I get to that, actually, I just want to say that at the time the legislation was introduced, again, even though, well, at the time the legislation was introduced, everyone agreed that it was retrospective. Yet, the government statement during the committee proceedings, where the legislation was being considered in the bill committee, said, "The government do not accept that the clause changes the meaning of the law. The law already applies to partnership profits, and we interpret that as including profits employed through a trust. The measure clarifies rather than amplifies the scope of the 1987 legislation and puts beyond doubt what most people understood it to mean. We recognise and acknowledge the difficulties inherent in such legislation. Although the clause is strictly retrospected, as was the case in 1987, it does not change what is generally understood to be the meaning of the law, but merely clarifies it." And it went on to say, "The government do not accept that the clause changes the meaning of the law. The law already applies to partnership profits, and we interpret that as including profits," which just is restating. So, I mean, there's this kind of slight nonsense in that the government is calling something retrospective, and yet when it is setting out what it believes to be the legal position of the clause, it's basically saying it's not retrospective. And I think that is the cause of some of the conclusion. Now, Mr. Hewitson sought to challenge this legislation via human rights law, saying it was incompatible with human rights legislation, and it was incompatible because it was an unjustified interference of his possession. So you have to look at, the court has to look at first whether he has a possession or not, because you have to have a possession for it to be interfered with. And it seems to me the court's view was no, he didn't have a possession because it wasn't his money in the first place. Now, in the High Court, it was Mr. Justice Parker, and he set out, what the purpose of tax treaties was, and it's a universally acknowledged in a contemporary society, a state is entitled to impose income tax on any person who resides in the state in question and who earns income there. It goes on to say, double taxation agreements, including the DTA in this case, typically respect the principle of taxation in the state of residence and seek to ensure that income tax is exacted by the state of residence and that persons are not taxed twice on the same income. The fundamental purpose is to avoid double taxation. It is not the purpose to facilitate the complete avoidance of income tax in any jurisdiction, or to allow residents of a particular state to reduce the tax on their income to a level below that which would ordinarily be exacted by the state of residence. Given these propositions, I see no basis for the claim that the parliamentary response to this case was disproportionate. Parliament, in my view, is entitled to conclude that legislation was needed to put in effect the DTA beyond doubt and prevent taxpayers resident in the UK from exploiting the double taxation agreement. And then it went to the Court of Appeal. Lord Justice Mumry, writing the opinion of the majority, in the circumstances of this case, the liability of the claimant under the retrospective legislation on Section 58 to pay the UK income tax that he would have had to pay had he not participated in the tax avoidance scheme is no more an unjustified interference with the enjoyment of his possessions than the ordinary liability of his fellow residents in the UK are under to contribute by way of the UK tax on their income towards the cost of providing community and other benefits for the purpose of life in a civil society. This outcome accords with the reasonable expectations of the taxation of residents in the state on the profits of their trade or profession. The legislation prevents the DTA tax relief provisions from being misused for a purpose different from their originally intended use. Now, if you're aware of the Ramsey principle, which is that taxing statutes should be applied and interpreted in line with the intent of Parliament, all that Lord Justice Mumry is saying here is he's applying the Ramsey principle to this case. And if he's applying the Ramsey principle to this case, he's simply saying that this was never a lawful means of avoiding taxation in the first place. So I think, in my view, often when we talk about retrospective legislation in the tax world, we're not really, it becomes very mixed up. It's not retrospective in the way that people commonly perceive it to be. As an aside, it is interesting that even David said at the beginning, we all agree that in certain cases, in the criminal courts, criminal law, etc., be completely unacceptable. We have had cases where there has been new criminal charges applied retrospectively in very extreme and circumstances, such as the War Crimes Act of 1991. But they're so rare that this is not what we're talking about here. So I think the question then becomes, I think, in my view, is whether it's right from a strategic point of view for the government to be using this as a tool, given that, in my view, it doesn't change often the underlying position of the taxpayer. And I think there is a question there about whether there is whether retrospective legislation strategically is the right thing to do, because often it legitimizes the idea that what came before it was lawful, because people can easily attack what the government's intent is by saying, if this stuff was lawful at the time, you wouldn't have required retrospective legislation to deal with it. However, I think often retrospective legislation is introduced just to make the administration of the tax system easier as far as HMRC is concerned. Now, that can have secondary effects which are important, as Stephen has set out, but I don't think it undermines the principle of retrospective taxation, it said. And then, just to finalize, I think, on some of these schemes, I think when you look at some of the underlying behaviors in a lot of tax avoidance schemes. It's not just a simple question of the tax legislation doesn't apply as people thought it might. There's actually a fraudulent intent in many of the tax avoidance schemes that I have looked at in the way they're created. So in that case, a 20-year limit would apply. And in the Rangers scheme that was raised, I mean, interestingly, there were two schemes that Rangers ran, one or two cases, one called the wee tax case and the other one called the big tax case. Now, as I understand it, in the wee tax case, HMRC did actually introduce or did actually start Code of Practice 9 investigations in that case because they thought there was fraudulent intent. And in the big tax case, I think if you look at the facts of the first tier tribunal judgment, I think it is very difficult to describe, in my opinion, I should say, for my libel lawyers, for any libel lawyers out there, but I think it's very difficult to describe the activities of some of the officials at Rangers as anything other than fraudulent. And so, you know, in my view, I think rather than introduce retrospective taxation or legislation, HMRC should pursue those remedies more frequently, which may be an even more powerful deterrent, because I think the deterrent of the Prima Rolo statement in 2005, although it was well intended, as we have seen from the history of the last 15 years, has perhaps not been as effective as they hoped it would be.
Thank you, George. And I'm going to pass on to Keith, who's going to argue against retrospective taxation being used.
Thank you very much, Emma. I was going to start by saying I agree with everything that Stephen has said because he's on the same side of this debate as I am. But actually, I'm going to agree not only with Stephen, but also with George, because George has very articulately made the case against retrospective taxation. George and I, as many of you will know, have had a number of interesting discussions over Twitter in which we've discussed the legality or otherwise of tax avoidance. But if George is right and that these tax avoidance schemes are, as he says, fraudulent, then, exactly as Stephen said, the revenue should use their existing powers to tackle what they consider to be the ill in society and not circumvent the taxpayer's statutory rights by using a retrospective provision for their own convenience in a way that undermines the rule of law. Now, even if you ignore the impacts on individuals who are affected by these retrospective provisions, when a government starts undermining the rule of law, it leads to a lack of trust. And the entire tax system, and in fact the entire society, requires there to be trust between citizen and the state. The other thing I would also like to say as an introductory comment is retrospective taxation is used, and I say inappropriately, not just in avoidance cases, it's again used just for the convenience of the government. And that's why it is so inappropriate. Just in this current Finance Act, we have seen retrospective provisions in relation to entrepreneurs' relief. Taxpayers who took actions which were lawful at the time, to use George's preferred terminology, which were clearly in accordance with the statutory provision, have been taxed more harshly because of a decision and announcement by Parliament at a later date. That, in my view, is wrong. Section 103 of the Finance Act attempts to legitimize the revenue's conduct of issuing Section 8 notices asking you to send in a tax return through electronic means. The government was not abiding by its own law, and it has been found that their approach has been unlawful. Therefore, the Section 8 notices issued in the past have been invalid, non-enforceable, and therefore penalties should not have been charged. This little oversight by the government has proven a little bit inconvenient, and therefore Parliament has been persuaded to enact legislation so that a former notice, which was invalid, therefore unenforceable, has now been deemed by Parliament to be enforceable and if you're too late to have sent in a tax return in response to that previously invalid notice, you are now liable for a penalty. That is just wrong. But most of this discussion has been focusing on tax avoidance. So I will be speaking from now on with tax avoidance in mind. And the next thing I will say will be 100% accurate, but 100% meaningless. I do not condone tax avoidance. The reason it is meaningless is that the term avoidance is extremely hard to define with any precision. And more importantly, there's no guarantee that people will be able to agree whether any particular arrangement is avoidance or not. Now, David has already referred to egregious avoidance. So some avoidance, he says, can be tackled by retrospective legislation legitimately, and some can't. But where is the boundary? Is it where you've identified a loophole in the legislation, or where you've just simply done something the legislation wanted you to do, but later Parliament decided they didn't want you to do? To use an example, and it's an example which I first found in the late Professor Tyler's book on revenue law, but a real-life example occurred a couple of years ago. This is where you have a couple, unmarried, been living together for 30 years, and one of them is about to die. And they suddenly realize they have a huge inheritance tax bill to deal with. So 2 days before the person dies, they get married. Not because they suddenly feel that it was immoral to live together unmarried, because they've been doing that happily for 30 years, but solely to avoid tax. The late Professor Daly said that is tax avoidance. It is a paper transaction entered into solely for the purposes of reduction of tax. Is that egregious? Well, who knows? But it's certainly a form of tax avoidance, but it's one which is clearly supported by the legislation, and therefore one shouldn't have that right retrospectively removed. That said, I'm happy to subscribe to the view that tax avoidance is a matter of personal morality. But so is every other or many other aspects of a person's life. Parliament could enforce a law or pass a law to say that one must act with integrity or morality. But that ultimately is going to be hard to enforce. Instead, what Parliament does is decide what is right or wrong in any particular circumstances, and then introduces legislation to make it clear what is expected of individuals and the consequences of non-compliance. Take some examples well outside the tax sphere. Driving through a red light is a question of right or wrong. It is no longer a moral question. What has happened is that the democratic process has decided to regulate driving, that drivers and cyclists must stop at a traffic light when it is red. Now, I'm possibly showing my age, but I remember the introduction of compulsory seatbelt wearing. Previously, it was down to personal choice, but Parliament decided to intervene and made it compulsory, and to issue fines for those who did not comply. Now, having lived with compulsory seatbelt wearing for the past nearly 40 years, most of us will probably say that wearing a seatbelt was, or not wearing a seatbelt, was highly irresponsible. And wearing a seatbelt was to some extent a moral obligation. So on that basis, we would probably agree that with the current state of the law, that there is a right of the state to impose fines for non-compliance. But I hope we would all object if, when the law was introduced, it had been backdated to catch non-seatbelt wearing at the time when the law was not yet in force. The morality of wearing seatbelts was no different in 1980 from how it became in 1982. Yet, people should be governed by the law as it stands on any particular day. And I believe that even David, in his opening remarks, made such comments. If society dictates that the law should be changed, then that is one of the advantages of living in a parliamentary democracy, and that new societal norms can be reflected by new laws. But such changes should be prospective so as to promote the concept of certainty. There's no reason for tax to be subject to a different set of criteria. Like the laws of the road, tax is part of a citizen's relationship with the wider society. Parliament has, quite sensibly, decided it cannot rely on each individual to volunteer his or her fair share, in the same way as Parliament has chosen driving speed limits that should be regulated, and not to, driving speed should not be left to individual discretion. Now, going back in history again, because of the confiscatory nature of tax, the courts used to adopt a very literal approach to the interpretation of tax statutes. David was talking about taxation under clear laws. This reflected the view that if the Crown was going to take something from a citizen, something that Magna Carta has ensured must emanate from Parliament, the legislation must make it clear what is within the charge. However, the last 40 years, the courts have started to take a different approach to interpretation of statutes. Now, this was best described with a bit of hindsight by Lord Steyne in the McGuckian case, when that was in the 1997, I believe, where he was looking at the pre-Ramsey approach, pre-1981, and he described that as tax law was then left behind on some island of literal interpretation. That approach changed with Ramsey. Now, we could debate the rights and wrongs of the new post-Ramsey approach, but that is clearly the subject of another debate. I'm certainly not going to defend the old approach today. The law is the law, and the court's approach to what the law should be the same whether or not it's tax law, the law of the roads, or something else. Tax law should not be left on an island. And indeed, that was confirmed when the House of Lords considered the next landmark decision on tax avoidance, the case of Barclays Mercantile and Mawson, where there's a famous passage which had actually been taken from the previous year's Hong Kong Court of Final Appeal in a case called Arrowtown. But what the House of Lords endorsed was the driving principle in the Ramsey line of cases, that it continues to involve a general rule of statutory construction and an unblinkered approach to the analysis of facts. The ultimate question is whether the relevant statutory provisions construed purposively were intended to apply to the transaction, viewed realistically. Now, it's fairly clear from that passage, but it's even clearer from the passage immediately before, that this is not a special law of interpretation for tax. Early in that paragraph, Lord Nichols had said, cases such as these, having referred to the earlier cases on the Ramsey approach, gave rise to the view that the application of any taxing statute, transactions or elements of transactions which had no commercial purpose, were to be disregarded. But that is going too far. The essence of the House of Lords decision was that that one has to look at the law viewed purposively to the facts viewed realistically. But what Lord Nichols had made clear is that the mistake on the previous interpretation of the Ramsey approach was that it allied two steps which are necessary in the application of, and I emphasize, any statutory provision, not just tax provisions. So it's quite clear that the courts treat tax statutes in the same way as other statutes. The role of the statute is no different whether it is tax statute or any other form of law regulating society. In the same way as retrospective legislation is reprehensible in any other sphere, the same protocols should apply to tax. Otherwise, we start leaving tax on yet another island. And if I just conclude by looking at the example that George raised, the War Crimes Act of 1991, that did not create a new offence. It did not create any new culpability. What it did is it reflected the fact that committing murder by a British subject anywhere in the world brings you within the realms of the UK courts. All the War Crimes Act did was extended that to people who were not British subjects at the time, but who later sought British and obtained British citizenship. The context was the Holocaust. And I'm not going to say that the War Crimes Act was wrong, but it was controversial. It was controversial. The offences it was trying to deal with were far more serious than even the most egregious tax avoidance.
Thank you, Keith. And thank you to all the panelists for what has been, very intellectually rigorous and well-argued comments. I just had a few, I'm going to sort of try and play devil's advocate to both sides, as it were. So to David and George, David, you mentioned, the issue of retrospective tax needs to be proportionate. And George, you mentioned that basically the intention of Parliament generally means that even tax avoidance schemes that claim to be lawful at the time are probably not. So I suppose my question to both of you really is, what do you think constitutes proportionate retrospective tax? Is it only to do with tax avoidance, or does it sort of start to fail when it's about the convenience to the government? And if it is just about convenience to HMRC, is it fair in terms of the certainty citizens can normally expect under the rule of law? So I'm going to pass that to both David and George. I'm not sure who'd like to come in first. Okay, David, yeah, come in.
Thank you. I think there are 2 points here, and they go to points that Keith has raised. First of all, I do make the point that a government should not use retrospective legislation for the purpose of correcting its own administrative failings. That I accept is wrong in principle. I think the boundary to be drawn between what is and what is not acceptable, or if you like to use the term egregious, tax avoidance, is very clear. It's been a clearly expressed intention, an intention clearly expressed by Parliament. So, for example, to take the example of the elderly couple who got married before one of them died to avoid an inheritance tax problem, that is clearly the right side of the line, because Parliament has clearly expressed the desire to encourage matrimony, and the fact that this is being done to avoid tax is not is entirely consistent with a wider principle of society, that matrimony is generally to be encouraged. So I would say that, to my mind, the boundary and where you draw the line in the sand is quite clear. And I don't think it's fair to compare this with traffic laws, because the purpose of taxation is to fund government. The purpose of traffic laws is to control the individual behaviour of the citizen. And I think those two circumstances are very different. George.
Thank you, David. I mean, I think David, Keith said something quite revealing about the marriage example, which is that it's tax avoidance clearly supported by the legislation. But HMRC's own definition of tax avoidance is acts that go against the will of Parliament. So if something is clearly supported by the legislation, I think it's very difficult to argue that that is tax avoidance, as has been accepted by HMRC or put forward by HMRC, and is the kind of definition that is pursued by the courts. And I think, when dealing with tax avoidance, HMRC has and the Treasury has a number of tools in its armory, of which retrospective legislation is only one of them. And I think that what it's seeking to do is, as I say, is going to is seeking to not change the underlying tax position. I think that's where that would be where I would draw the boundary, right? If it's not changing the underlying tax position in the first place, I think that is a fair line to draw. Now, when it comes to and I think a good example of this is the Rangers case, right? The Rangers case, HMRC started their inquiry into Rangers in 2004, and the Supreme Court judgment, I think, was 2018, Court of Appeal 2016. You know, that's a very, very long time to resolve these issues. And in the meantime, literally tens of thousands of people were brought into similar avoidance schemes. So I think it's, you know, not unreasonable for HMRC and the Treasury and the government to pursue legislative remedies at the same time to prevent, you know, in the years that will go past whilst the litigation process completes, to put a kind of marker down. I think where, again, there is it's problematic if they don't introduce the legislation in good time. So I think that is a legitimate criticism of the loan charge, is that, you know, HMRC knew about these schemes for a very, very long time, and yet the legislation which finally was meant to draw a line under them was put in place, you know, a few years ago. And I think had they been more aggressive earlier on, a lot of people might have been saved a lot of grief. And I think that's an important point.
Okay, yeah, before I ask the question, yeah, did you want to respond, Keith or Stephen, to either the points David or George have made?
Yes, thank you, Emma. I just want to before I respond, I just want to ask David a question. Would you consider the IR35 legislation announced in 1999, put into effect in 2000, as retrospective, anti-avoidance legislation? Yes or no? You're being cross-examined.
Sorry, would I?
Would you consider IR35 to be anti-avoidance?
No.
Okay. So the fact that the IR35 press release talks about countering avoidance, I think is its heading, and refers to avoidance 4 times in the opening couple of paragraphs, you think that's just political posturing?
Yes, those are drafted by officials of HMRC. I think there's a danger that people in our position, Keith, focus too much on the technical mechanics of the collection of taxation. And if you take a few steps back and you ask yourself, the appropriate way to collect fairly taxation on earnings of an individual who provides their personal services, is IR35 consistent with that? And I would suggest to you that it is.
Okay. Other than the fact, I'll then respond in 2 ways. One, someone who is genuinely self-employed can nevertheless get taxed in different ways depending whether they go through a limited company or in a truly unincorporated self. So the fact that earnings for the self-employed can have separate tax treatments doesn't justify having a uniform treatment for individuals who are effectively employed.
No, there's a clear distinction between someone who's self-employed and someone who is genuinely employed in the employment law sense and is engaged for their personal services by somebody in circumstances caught by IR35. It's quite clear from the legislation that if you're genuinely self-employed, you're not caught.
Absolutely.
Okay, but before we get on to IR35, which we could be here all day for that.
Okay, the second point, we'll discuss IR35 another time, Emma. But the other point that David has very helpfully made is we can ignore the press release wording from 1999 for the sole reason it was drafted by HMRC officials. But that completely undermines what George has just said, in that he has relied upon not my definition of tax avoidance, or not the late Professor Tyler's definition of tax avoidance, But the definition of tax avoidance that we have to work forward with is that put forward by HMRC. I was going to disagree with it anyway, but you've managed to show that that is not the HMRC and not the arbiters of what is and what is not tax avoidance. So
Parliament should be the arbiters.
Yes, or the courts.
Okay. Well, primarily Parliament. Well, I mean, the question I had to, sort of pose to both Keith and Stephen is on the issue that David and George have mentioned, that there are people who are determined to set up, tax avoidance schemes in particular, a whole bunch of promoters. I know that Tom is very aware of some of these and the phoenixing of companies. So my point is, what practically, because if you agree with David that the purpose of tax is to fund the government, what is government supposed to do about these promoters who are always potentially going to be one step ahead of them? Like, what do you propose that they can do? And isn't it fair in that situation that retrospective tax should be a tool they have? Yeah, Stephen, did you want to come in?
Okay, I'll come in first. So that's an excellent question. And definitely it really hurts the gut when you see people up to all kinds of shenanigans and not paying their taxes when you are paying your own taxes. Now, if the law actually works, what you could say in response is, well, HMRC should have sufficient resources to be able to chase after these people. If the law doesn't work, so it does actually allow for these loopholes, then the laws ought to be changed in the first place. Now, one of the consequences of living in a system governed by the rule of law is that there are going to be cases at the margins where people take the mick, but they still get away with it. And I don't have a particularly satisfying answer to that, but if we take the rule of law to be serious and a value that is worth respecting, then that is just something that we have to put up with and live with.
I completely agree with what Stephen has said, and I'll just add one thing. We've already heard about some of the events in 2004, but the Finance Act of 2004 actually introduced an early warning system. So Parliament has recognised that it can be difficult to legislate to prevent tax avoidance. Now they've got early warning, and therefore they can take action swiftly when they need to do so. And I don't think Stephen and I will object to an idea that Parliament can get an announcement. I personally am even happy for a proper press release to say, with effect from today, the law will be changed in legislation to be announced shortly.
Did David or George, did you want to come back on either of those points?
The short answer to that, Dawn from Rollo did say exactly that, but she qualified it by saying, and we will come back to 2004 if necessary. So clear notice was given in Parliament in 2004.
Okay. Well, I mean, to actually come on to the loan charge more specifically, I mean, we have touched on it quite a lot already, but considering it as the most sort of topical issue in the area of maybe not speculative, but retroactive tax, I just want to ask each of the panelists, do you think this was a good policy? What do you think, if anything, should have been done differently about it? I'm going to start with Keith, because I think you're unmuted already. So,
the loan charge legislation is an absolute absolutely shocking piece of legislation. It was introduced in an underhand way. It was subject to consultation, and the consultation was fudged, or the consultation response was fudged, so as to make the extent of the objection from the professional firms watered down, so that it was effectively hidden. Almost the problem was with the consultation is that so many people responded that they were the people who were adversely affected. So that when the Institute of Chartered Accountants said this is retrospective taxation and it just goes too far because it undermines the rule of law, The response document said, we got 400 responses. Most of them were from people who were directly affected by it, and therefore they could effectively ignore that very important and fundamental objection from a respected professional body. Every aspect of the loan charge fiasco has shown that HMRC were doing absolutely everything to cover their own backs. They've even admitted that what the purpose of the loan charge was not to get the tax that they thought they wanted, but was to make it easier by making the litigation process that it would otherwise have to follow much simpler. So it was done for administrative convenience, and it was done simply because of the consequence of the Rangers case, which confirmed, yes, this was employment income in most cases, but the liability for the tax on the employment income comes from the employers, and the revenue had not effectively chased the right people at the right time. Rangers was a massive own goal, keeping the footballing analogy, and therefore the loan charge was a device to pass the liability onto a party that was not necessarily completely innocent, and I think there's a range of levels of guilt of the participants in the loan arrangement schemes, but they were not the only participants, but they're the ones who are going to face the full brunt of it, and it's an affront to democracy because it casts aside the protections of the statutory safeguards which Stephen was talking about earlier.
David.
To a large extent, I agree with Keith. This was the decided remuneration legislation was out in 2010. That was cost in terms of imposing a levy on individuals. It was always my view, and I know that of others at the time, that what they should have done is cast it in terms of a levy on the company, in much the same way that we have a loans to participators charge under Section 455 CTA 2010. It was open to the government to have said, where a company or an employer puts beyond reach of its creditors any asset, it has an immediate liability to deposit, let us say, 45% levy on that amount with the government, which can be used as a credit against anything that comes out subject to PAYE and NICs. I was told very clearly by officials at the time that they chose not to structure it that way simply because politically they did not want the charge to be perceived as a levy on business. It was to be perceived as a levy on the individual. I think had they gone down that road, it would have been much simpler and would have stopped to a lot of this egregious tax avoidance at a very much earlier point in time. So yes, the politicians were at fault, but let us not forget, and it's the QCs whose opinions were relied upon in support of all these schemes. They have avoided having a opprobrium heaped upon them, and there's something delightfully English about the way we bringing to book our very senior professionals, as if once you get to a certain level of seniority and age and expertise, you're beyond reproach. I think that is very sad. And lastly, yes, of course, the revenue should be resourced to a level which enables them to take issue against promoters, including QCs and others. There was a report last year that an investigation had been opened into one well-known QC involved with these, but so far as I'm aware, no positive action has been taken under the promoters legislation.
Stephen, yeah.
Okay, thanks very much. I'll reiterate a couple of things that I already said. So one is, as I said at the very beginning, I've got no skin in the game here and I'm just here for the debate. But I'd just reiterate also the importance of statutory time limits. So I'll defer to my opposition at the moment that let's just assume that these schemes didn't work in the first place. And going back, all that was happening through the legislation was making clear that these schemes didn't work in the first place. I'll defer to them on that. That still doesn't justify, though, the ability to run right through the statutory time limits that are put in place in the first place. They are there for a reason. And it seems that that logic behind the graduated time limits was lost through the introduction of the loan charge.
Except that if someone is still enjoying the benefits, should they not be, should the government not now be able to recover that ab initio? I take your point that it goes way beyond the cost of finance in the quantum of the charge, but that's a slightly different point. If in principle it's open to the government to put a stop to it, I see no reason why they shouldn't say that if you can either repay the loan today, or if you don't repay the loan tomorrow, you get taxed on it tomorrow. That seems a perfectly fair and reasonable action.
You're taxed on it, you still owe it.
But the trustees can't have it both ways. Yeah. Was it a loan or was it earnings?
Well, I think if I was to jump in there, I think that's exactly what's happening with some of the trusts. HMRC are taxing it as income, but yet the trusts are selling the loan books on to third parties who are recalling the loans. I'd say it's HMRC that can't have it both ways, in my personal opinion.
But hang on, who's the guilty party there?
Well, I think there's definitely an argument that the trustees are in breach of fiduciary duty, but we're still arguing, is it income or is it a loan?
And why aren't the trustees regulators in Jersey, Guernsey, Isle of Man, where trusteeship is a regulated activity? Curiously, it's not in this country, but where it is, why aren't the regulators coming down on those trustees like a ton of bricks?
I 100% agree that they should be, absolutely. Question for them.
But they're not.
They're not.
Maybe when you get to a certain age and a certain status in society, you're untouchable.
Maybe.
Someone once said recently.
Yes.
Indeed. George, do you want to come in?
Yeah, and I would say, look, I think it's a very difficult issue. I mean, I think on the one hand, I agree with the idea that you need to have a balance between the interests of the wider tax-paying public, and even with the more reforms, there is a bit that sticks in the craw, which is there are many people there who would have got away with paying a single-digit tax rate on their income for many years, enjoyed a quality of life better than anyone else who was doing the same job as them and paying their taxes appropriately, and now they've been cleared in that, and that really does stick in the craw. But I also agree with Stephen that at the same time, you are going to get cases like that, and that's just one of the costs we have to live with. I think for me, the biggest problem with the loan charge is that it has given HMRC an excuse and a mechanism to continue to focus on the end user and to not do enough to tackle the promoters and the marketers and the designers of the schemes, who I think would be culpable under criminal law and at least under civil law. And I think actually they would be, in some of the schemes I've seen, some of the users would be able to bring actions against the promoters for the schemes that they were sold, because what they were sold was clearly not what they were being told. And I've seen that, HMRC's recently put out a spotlight about people continuing to sell loan schemes during the COVID crisis to people coming back to work in the NHS. And I've looked at some of the stuff that's been on offer and some of the marketing material that has been given to people because I phoned up one of the schemes and asked to see it. And, what was being said there, that, their new way of just simply calling your second part of your income an advance on future profits, which is tax-free and in line with the latest HMRC rule changes and wouldn't be caught by any legislation, is just clearly bollocks. and it's and actually in a way that will end up hurting people financially, and more than financially. And that behaviour needs to be tackled, and I don't think HMRC has been doing enough of that. And I do think the loan charge has given them excuse not to do that. And I think, for me personally, that is the biggest problem with the loan charge.
Emma, if I could just add in,
Yes, of course.
the Revenue's public stance on the loan charge was to stop these kinds of schemes. It is quite clear that if that was their official aim, it has officially failed. My personal view is it was never their official aim. That was just the political excuse for introducing legislation.
Well, on that point, actually, because this leads me to my next question, which is about the lack of tax regulation in the UK, and whether or not it's fair. It can be seen to be fair that we can have retrospective or retroactive taxation like the loan charge, if arguably taxpayers are not getting protection from the experts, whether that's HMRC following up on people's use of things quickly at the time, or actually a regulated body of tax advisors. I know it's not quite specifically on should retrospective taxation be permitted, but it's part of the context of this conversation. So I'd just be interested to know what you think about that. Who wants to pipe up?
Promoter would send.
Sorry, I missed that, David.
Failing a promoter would send the right message. So far as I'm aware, nobody's actually gone to jail, been fined. But knows to the contrary. I don't think anybody has been committed and sentenced to imprisonment. And of course, a lot of the schemes that George described are downright fraud and conspiracy to cheat public revenue. And the problem is that a lot of these promoters are situated in Cyprus, Malta, jurisdictions where we don't have extradition treaties, or we don't have the right proceedings in place to be able to effectively take action against them.
Okay. So do you think then, I don't know, does that make you think differently about some of the people who use these schemes if, as George has found out, some of the things they say sound plausible potentially?
I have every sympathy with those who are drawn into these schemes. Prominent MP last Saturday evening who said that so far as MPs are concerned, the evidence that has been provided to them has not convinced him or his colleagues that a lot of these individuals did not know that the end result was that purportedly pay less tax and have more in their pocket, and that was what drove them to participate in these arrangements. So he gave that as the reason why he was very reluctant to support any further relaxation of or amendment of the loan charge.
If I could just jump in on
that
as well, and I think there was a case. I think it was in 1995, Regina versus Charlton, where the state actually imprisoned some accountants and a barrister for the design, sale, operation of a tax avoidance scheme. Now, you look at the tax avoidance scheme that they were put away for. I don't think it is in any way worse than many of the tax avoidance schemes we've seen over the years. But the lack of any action allows this idea to perpetuate that these things are avoidance and avoidance is legal, and so everything being done is okay. And I think that is the real problem. The idea that tax avoidance is legal and these things are tax avoidance is the greatest marketing trick that some members of the industry have promoted. in order to bring people into these schemes. And when HMRC starts taking real action against some of the schemes and bringing criminal prosecutions, that will change.
Thanks, George. And I'd seen Tom was shaking his head to some of what David was saying, so I was just going to offer you a chance to comment if you wanted to.
Yeah, I think that's very much personal experience. When you talk about tax avoidance, the government have done a very good job of painting the typical tax avoider as a six-figure or higher earner who's looking to minimise tax. I mean, I've spoken to social workers, NHS bank staff, people earning they're not higher rate taxpayers, and essentially they were paying fees to these companies that totaled the same amount that they would have paid in tax had it been deducted correctly. So to say that people are going out and deliberately trying to minimise their tax, I think is a very broad brush, which I wouldn't agree with. And I don't wish to speak for Keith, but I dare say Keith would be of a similar opinion of speaking to some of the people he has.
Absolutely. I think I've met dozens of people who participated in these arrangements. One says, yes, she knew full well what she was doing. She was a much higher earner. Others were simply told, right, we've got a job for you by the agent. The agency phones on a Friday afternoon. We've got a job for you. Sign up. Do you want to go to work this umbrella company? These are often working for government departments, in some cases HMRC. HMRC themselves knew about these people, and they could have seen the mismatch if they'd looked. The revenue said it was always our position. If it was always the position, then they could make their position clear. They didn't.
But I think that is the tragedy of the situation, and that really exposes how much of a scam some of this stuff is. If essentially what's happening is an employee is being taken on by a scheme, and the scheme operator is essentially giving that person no financial benefit, avoiding all the taxes, evading the taxes, and keeping that money for themselves. And that just shows how much the scheme promoter is scamming their client. But that doesn't make what the system that's happening okay.
That's why the loan charge itself is immoral. They're going for the victims.
And particularly the fact that a lot of these promoters claim that they have the benefit of a QC's opinion that says this is all hunky-dory. And so the focus of the action needed to be taken to put a stop to this should also be on the QCs and the lawyers who are behind this. And there's been very little comment in relation to those individuals in the press. But I do accept that one other way that the government could have approached this would be to say, all right, let us, rightly or wrongly, treat these as shams. We will accept that received by way of loan was probably taxed as earnings and structured on that basis. Now, they chose not to do that. And that political decision, I would be critical of. I concede that, but they've done it in a particular way, and we are where we are.
Okay, thank you. I know we're sort of coming up to, well, I know everybody wants to sum up their key arguments, but before we get on to that, I just wanted to sort of move the discussion on a bit in terms of thinking, moving past the loan charge, as it were, in terms of retrospective tax. Do you think that we're likely to see more retrospective tax given the current, economic climate? Is the government going to be using ways of clamping down to get more tax to shore up the finances? Or do you think that actually we go through a sort of similar level of retrospective tax? It's not affected by economic circumstances. So yeah, what do you think we're going to see? I'm
Well, I
going
hope not, because if they withdraw the principal private residence, I've got a problem.
Yes, I don't think you'd be alone there, David.
I think you have to look at the two drivers, and I think David was very right to say that one of the key drivers of retrospective legislation is a minority of tax advisors who are seeking to push against the envelope all the time. And as long as that is there will be a tendency. And then on the other side is the capacity of the state to deal with these schemes by other means. Now, I think, you've looked, HMRC has reduced the amount of tax inquiries, assessments. It's done by a third over the last couple of years. Over the last 10 years, its headcount has dropped by about 50%. And I think its cash budget is now smaller than it was when Inland Revenue and Her Majesty's Customs merged. So from a tax capacity point of view, there is a driver and there'll be an incentive for more retrospective taxation from that, which is not a good incentive at all, and not one I don't think anyone would support. Whether or not there is still this pressure from people seeking to game the system, to a certain extent that will always be there. Whether it's worse than it was in the past or not, I'm not entirely sure. But some of the stuff that's been coming out recently about what people have been doing in the recent Moneybox investigation on the BBC would suggest that it's still carrying on with abandon. Yes, I think there will be.
Okay, no, thank you, George. Yeah, Keith.
You asked the question whether retrospective taxation will be introduced yet again, given the number of retrospective provisions in the last few finance acts, not just 2000 number second one of 2017, but it's just now becoming a regular occurrence. The revenue have got addicted to this clever concept. They can get more money just by making retrospective provisions. So it's a very tempting and now very easily done because it's there's a precedent. Whether they should, I say no for all the reasons we previously discussed. But if I can summarize it in a nutshell, there are going to have to be some large tax rises to help this economy recover. But in order for there to be public support for these large and uncomfortable tax rises that I expect, the government has got to restrain itself to ensure that there can be a continued sense of trust between citizen and state.
Thanks, Keith. Stephen?
Okay, so do I think that it'll happen? Well, politically, it goes down pretty well to say that we're going to get more money from tax avoiders. So there's always going to be that temptation for politicians to come for that. And if it is true that these schemes are still being promoted, then it's very likely in the future that, the government will reach for that particular lever and, use retrospective legislation to come after tax avoiders again. In terms of generating the monies to deal with the recovery, I think, it wouldn't generate a huge amount of money. Far more likely what we're going to see is, neutralization of the difference in NICs between employed and self-employed, probably a couple of changes to capital gains tax. Maybe something will be revisited in terms of inheritance tax and some of the reliefs there. So we'll see a broadening of the base more generally in terms of those taxes rather than, just going after tax avoidance to generate the sums of money that are needed to actually deal with the recovery.
Great, thank you. And David?
I think we must be careful here. Keith, the changes to the last finance bill were not retrospective. Withdrawing a relief which might otherwise have been available to you going forward is not retrospective taxation. There was some forestalling, but that was entirely consistent with the idea that the legislation takes effect from the date of announcement. So in answer to the question...
I'm going to intervene at that point. Obviously, one of the things we haven't even discussed about is the definition of retrospective rather as opposed to retroactive, but let's leave that aside. The entrepreneurs' relief rule which I was objecting to was the one which said for all transactions where a disposal was agreed back to the beginning of the tax year, but not completed until after the budget speech, will be subject to the post-budget speech time limit, even though capital gains tax, at least since 1971, has always maintained the view that you look at the disposal at the date of agreement, not date of completion. And effectively, Parliament, they called it anti-forestalling. It wasn't. It was effectively anyone who actually, anti-forestalling was, we have an announcement, we haven't yet legislated for it, we're going to plug the gap with anti-forestalling legislation. This was, we're going to say, well, what you did last month was acceptable then, in accordance with the law as it then existed, but we're now going to say it's going to be taxed differently. That's why I object.
David, did you come back on that, or?
I did not read up on the finer points of entrepreneurs relief in preparation for this. It would be a foolish man who took Keith to task on the detail of that, and I'm not going to put myself in that position.
Okay, wise move, perhaps. Great. Well, I don't know. I mean, did you want to just keep, because you mentioned very briefly the difference between retroactive and retrospective, and I'm interested to know what you think are the key differences, but I'm also somewhat terrified that it might go on too long. So if we could keep it a little brief, that would be great.
It shouldn't be controversial. One is taxing an earlier event differently from how it should have been taxed at the time the event took place. One of them is taxing a future event which in somehow impacts upon a prior decision. I personally would say the former is retroactive and more heinous than retrospective. But for some reason, the CIOT, and I think Parliament now, uses the terms the other way around. To give an example of what is not offensive to me is someone deciding that next year the capital gains tax rate will rise to 30%. So even though I might have an asset now, which I currently expect to pay a 28% capital gains tax rate on, I might find myself paying a higher rate even though I already own the asset. That's retrospective to an extent, but no one in this panel, I think, is going to disagree with that as an approach. What I object to is having made a disposal today on the basis of a 28% rate, and then find out tomorrow the government is going to backdate the 30% rate.
Okay. Anyone want to come in on that?
I wouldn't disagree.
Okay. Great. All right. Well, thank you very much for that very interesting debate. I'm going to open it now to each of the panelists to go through their key arguments to sum up. I'm going to start with David, please.
Well, I'll try and be very succinct. I think the point is that any government needs to raise funds to finance society as we know it. And it is incumbent on government to make clear in legislation how it intends to do that. But given the propensity of the tax community to, as someone said earlier, kick against the envelope and try to find every conceivable way of minimizing the liability of X and thereby imposing a greater liability on Y, it seems to me perfectly fair and reasonable to allow government a degree of latitude to ensure fairness as between taxpayers. And where it has made clear its intention of levying tax on a particular type of transaction, particular type of income, or particular type of behaviour, and it is subsequently found not to have achieved that, then it seems to me fair and reasonable where it is consistent with the original intention and the original announcement to legislate retrospectively so as to plug the gap. As an entirely separate matter, I think we're all agreed that the revenue should be resourced to take more effective action against those who promote these schemes. And I think we are all agreed that as a matter of principle, and aside from the exception that I've just referred to, it is not appropriate for a government in a democracy to legislate after the event and change the consequences of something that happened before the event. But there is a very grey area as between doing so prescriptively and doing so consistent with a clear intention voiced by Parliament. So I will rest our case there.
Thank you. And now.
Well, I'd just start in response by agreeing completely with what David said about properly resourcing HMRC. And George has made the point that we've seen over the last decade a serious decline in the finances available to HMRC. And that really does need to be rectified. So if one thing that we can all agree on, hopefully, it is that HMRC ought to have more resources so as to be able to go after the bad people in the first place. In terms of my argument, I would just, well, in response to some of the claims that were made earlier, a lot of it was predicated on what legally can happen. And we heard a couple of big hitters that were used, you know, who it's in, Ramsey, Article 1, Protocol 1. And I think it's important to distinguish between what legally can happen and then morally what ought to happen. Because Parliament can do whatever it wants legally. You know, if Parliament wants to ban smoking on the streets of Paris, it can do that. But how you guide your actions then has to be driven by different values beyond what legally can happen. And in response to that, I think that those values that we ought to place importance on are things like human dignity, giving people the benefit of the doubt, trust in administration, and more broadly, democratic principles. The rule of law, as I've defined it for the purposes of this debate, is not a legal definition of the rule of law. It is very much a moral concept. It is about what ought to happen, how we ought to construct the state, and how law ought to operate. It ought to constrain the arbitrary exercise of public power, because the arbitrary exercise of public power is scary. Now, where retrospective taxation then seeks to override the rule of law through eliminating the statutory time limits that were set out in advance and that were supposed to regulate HMRC inquiries, that is wrong. And that is all I would say in my summation.
That's great. Thank you, Stephen. On to George now, please.
So I think I would say that what I think has been quite interesting about this debate, I think that there is broad agreement that retrospective taxation or retrospectivization tax is actually not a great thing. And it's not a great thing either because you disagree with the changes it's going to make itself, or because we accept it's driven by the need to counteract bad behaviors. And in the end, if it wasn't for that bad behavior, we wouldn't require this thing. It's a tool often used in sorrow more than in anger. And I think that is really something that needs to guide us in this. You know, the principles by which our legal system works are to try and ensure justice, and justice meaning fairness between different sections of society. And there must be a strong counteraction to attempts to avoid taxation precisely for that reason, to not allow people to get out of their social obligations in a way that is not available to others. Now, retrospective legislation is one tool in the armory that can help achieve that goal. It is not by far the only tool. And it's perhaps one that's used too often in recent times. But that does not mean that the actual tool itself is something which should not be allowed, because it has to be open to governments to administer the tax system in a way that is fair between different taxpayers. It is also, as we've kind of agreed, I think, incumbent on the administration to pursue tax fraud and to pursue avoidance schemes which are fraudulent much more aggressively. But those other tools have their shortcomings too, and therefore it must also be open for the government to pursue legislative means to achieve, to redress the balance between different sections of society, between the general tax-paying public and people who seek to get out of their social obligation.
Brilliant. Thank you, George. And Keith, please.
Thank you. Well, as George has already alluded to, there's actually an awful lot of agreement between the different sides of this debate. And the areas of disagreement are actually probably quite small. But what I want to focus on is David disagreed with my likening road traffic law and tax. And I maintain the view that different strands of law should be governed by the same principles, especially when they are looking at how society interacts with each other. For the tax system to operate, there needs to be an element of trust. Retrospective taxation erodes the trust and therefore should be avoided.
Okay, well, thank you very much, everyone, for what I think has been a fantastic debate. I think that we brought out the key sort of issues of balance between certainty and taxpayers' rights to protection, but at the same time, the revenue's right to collect taxes and the difficulties of shutting down loopholes. And yeah, it's been very great. So thanks very much. And now I'm just going to pass over to Marla.
Brilliant. Thank you, everyone. Thank you to our panelists. Thank you to Emma for chairing the debate and keeping control of everyone. Please do feel free to share this video and let us have your comments either below. You can email us. Our email addresses are going to be on the front screen. So thank you very much and hope you enjoy.